Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court. As always, I hope you're having a great day. For today's story, we turn our attention to official social media and what makes for official social media. Many people who have office in this country, whether they be federal, state, local, school board, sheriff, dog catcher, if those people are still elected, have social media accounts. Now, it is possible, of course, that those social media accounts are purely personal, because a person, just because they're elected office, doesn't necessarily mean they're always that office for all purposes. They can have a life outside of their official job duties. So we have a potential issue. When is a social media account official in some sense? When can it be said to be governmental? Because what we're concerned about here is people being censored, blocked, restricted, or otherwise unable to engage in social media on accounts that are of public figures. And by public figures here, I mean governmental officials. Now, some of you may remember during the Trump administration that Donald Trump blocked some people on his Twitter account, which he was using at the time. And some people, perhaps most notably Alexandria Ocasio-Cortez, but not only her, cried foul. They said that Donald Trump should not be able to block these people from his social media accounts because these were official accounts. And fast forward about 2 years later, and Alexandria Ocasio-Cortez herself was blocking people from her social media accounts. And so, like, well, it's like we have the right to complain about it until it happens to us. But of course, we need to find a uniform rule. This can't come down to Donald Trump, nor can it come down to Alexandria Ocasio-Cortez or any other official. The question at hand is, when is a social media account a governmental account? When is it an account of the governmental official of the government? When is it the government's account? Because then, if we're blocking people, muting people, deleting people, then we're in a First Amendment analysis. Now, that doesn't mean necessarily that we can't block, delete, restrict, mute them. It doesn't necessarily mean that. But it does mean we're in a First Amendment analysis, right? If it's not governmental speech, we're not in a First Amendment analysis at all. So if you conclude that the account is just a purely personal account and that the fact that they're a governmental official is neither here nor there, if it's just a purely personal account, then, do as thou will, because the First Amendment isn't implicated, because the person is just acting as a person. So it's only when the person is acting as the government that we would ask First Amendment questions. So we turn our attention to these twin cases, which are the first time that the U.S. Supreme Court has attempted to answer this question. When is a social media account governmental? When is it the government's account? Or when are you so intertwined as a governmental official that there's basically no difference? And then, of course, once we make that conclusion, then we can start talking about blocking, muting, restricting, throttling, or whatever by the governmental official, by the way. This does not apply to Twitter. This does not apply to Facebook. So this has nothing to do on its own terms with whether or not Facebook or Twitter or any other social media platform deletes, restricts, mutes the content. That is not the issue. It is only if the governmental official does it. So if Twitter themselves does it, then, no one cares. It's only if the politician themselves, only if the office holder themselves, or someone acting on their behalf, does it. Then we're maybe talking about governmental action and maybe we care. All right. So to try to answer this question about when is a social media account that is connected to a governmental official, when is it a governmental account, we turn to these twin cases. And we begin with Lindke versus Freed, because the other decision is just a, go decide the case in light of this. So there were two cases ostensibly, but we really only decided one because the other depended on the one. So fine, let's go ahead and read this and see if we can figure out when governmental conduct is implicated in social media accounts. Let's go ahead and get started with this. All right, Mr. Freed, like countless other Americans, created a private Facebook profile sometimes in 2008. He eventually converted his profile to a public page, meaning that anyone could see and comment on his posts. In 2014, Freed updated his Facebook page to reflect that he was appointed the city manager of Port Huron, Michigan. So at some point, it was purely a personal account. It started that way. It started as a purely personal account because he was just a guy. But at some point, he became a governmental official. He was appointed, but he's a governmental official all the same. He's the city manager. Fine. So he's the city manager for Port Huron, Michigan. On his page, which, started its life as a private page, he described himself as Daddy to Lucy, husband to Jesse, and city manager, chief administrative officer for the cities of Port Huron. Now, it should note, however, of course, that this may largely depend, and probably will depend, on how the page is represented. So if it's represented purely as a personal page, then, fine. But when you start throwing in governmental titles, and you start throwing in, because the governmental title doesn't belong to you, right? It belongs to the government. You're just borrowing it, all right? It's not, strictly speaking, yours. It's the government's, because it's the difference between the office and the man. You're holding the office, but it's not yours. It's the government's office. It's the government's title. You're just borrowing it for the moment because you were elected, appointed, or whatever. So if you start branding your page as saying, start using governmental titles, maybe that sort of indicates or is leading us towards a idea that this might be governmental. So the fact that it is labeled, that his page is labeled as he is the city manager, might be part of the analysis, at least in part. Let's continue. Freed continued to operate his Facebook page himself and continued to post prolifically and primarily about his personal life. So maybe it's personal. Freed also posted information related to his job, such as highlighting communication from other city officials and soliciting feedback from the public on issues of concern. Right now you're inviting the public to participate in a public way regarding the public. You're inviting them to talk to you in your capacity. Right? So maybe that's the thing. Let's read some more. Freed often responded to the comments to his posts, including those left by city residents, with inquiries about community matters. So people asked, hey, I have an official question. And he responded with what looks ostensibly like an official answer. So now it's looking more like government communication. Please take note that we have commingled communication. And much like commingling money, this leads to problems. Right? If we just completely segregated off our personal account and just talked only personal on our personal account, right? And only talked business on our business account, that would have been great. But much like commingling money, things get dirty. It started off as a purely personal thing, and now it's also a governmental thing. And now we have both, I love my daughters, they're great. And let me tell you, and let me answer your questions on behalf of the city because I'm the city manager. We have commingled speech, my friend. Things get uncomfortable. So have we converted this private thing into a public thing? Yeah. Don't commingle. It's a good plan. He occasionally deleted comments that he considered derogatory or stupid. Yeah, okay. Well, if it's the government, if he is the government in this role, if it is the government pressing the delete button, well, we might have a problem because people have the right to petition their government, don't you know? Particularly when he says, "Please petition me." That's what he said, right? I want your feedback on the city. Please ask me questions. That sounds suspiciously like, please petition me. I would like you to petition me, the government. And people are like, okay, I'm petitioning you. And then he deletes the petitions because they're dumb. That is not one of the available options when it comes to the right to petition. All right, so we have problems. After the COVID-19 pandemic began, Freed posted about it. Some posts were personal and contained information related to his job. Again, we're commingling. Commingling makes things uncomfortable. Facebook user Kevin Lindke commented on some of Freed's posts, unequivocally expressing his displeasure with the city's approach to the pandemic. Hey, city official, I don't like what you're doing very much. Would you please stop doing that? It sounds like a right to petition to me. Or it could be, because we got problems. Initially, Freed deleted the comments. Ultimately, he blocked him from commenting at all. Initially, Lindke I don't know how we're supposed to say this guy. I'm calling him Link for the remainder of this exercise. Link, that's his name, don't at me. Link sued Freed under 1983, alleging that Freed had violated his First Amendment rights. Yeah. As Link saw it, he had the right to comment on Freed's Facebook page because it was a public forum. He certainly did invite people to talk to him on the forum. So, there's that. The district court determined that because Freed managed his Facebook page in his private capacity, and because only state action can give rise to liability, the claim failed. Which, if it's true that it's only his personal capacity, if that conclusion is true, then the second conclusion flows, right? If it is truly correct that he only operates it personally and privately, and the governmental speech is kind of neither here nor there, then fine. And then if it is purely personal, then the First Amendment doesn't apply and go away. Okay, the Second Circuit affirmed with that conclusion. We see no governmental speech here. He can do as he will. Okay, let's see what the U.S. Supreme Court has to say on the matter. Held, a public official who prevents someone from commenting on the official's social media page engages in state action under the relevant law only if the official both possessed actual authority to speak on the state's behalf on the particular matter, which makes sense because if you are not in the role of that part of the state, then you're not speaking on behalf of the state, right? If you are, I don't know what the scenario is here, but if you're elected dog catcher and are suddenly commenting about the finer points of, I don't know, tax issues, then probably not your domain. The government has taxing authority, but not really what you do. So you might not be speaking in your governmental capacity because it has nothing to do with what you do as your job, which is fair enough. We got to confine things into the right domain, so that's fair. So first, you got to possess actual authority to speak on the particular matter and purported to exercise that authority when speaking in the relevant social media posts. So maybe we're doing this on a post-by-post level, which, is one way to go about it. So we're going to try to say, okay, we're going to try to have it looks like we're going to try to have our cake and eat it too. So you're only the government when you're the government. So we're going to allow you to commingle speech, and then we'll just have to uncommingle it after the fact, which is probably correct, but leads to a lot of complications. Best practice is just segregate it out in the first instance, and then you don't have these problems. Let's read a little bit more. Section 1983 of the federal law provides a cause of action against every person who, under color of law, of any statute, ordinance, regulation, custom, or usage of the state, deprive someone of federal right. Are you working on behalf of the government? Did you interfere with someone's rights? Section 93 under the color of law text makes it clear that the provision is designed as a protection against acts attributable to the state, not as a private person. Although it's not mentioned here, it is also worth noting, of course, that a private person may also become the state if they're sufficiently intertwined with the state. So, although it is somewhat rare, it is not unheard of for a private person to be deemed the state when they get sufficiently interwoven with the state. One of the classic examples I like to use to illustrate this point is, suppose the police, for whatever reason, really want to search a home. And suppose, for whatever reason, the police cannot get a search warrant. So suppose the police hire a private investigator and say, hey, private investigator, would you like to go look in this home? And the private investigator says, I sure would. Right. Okay. Congratulations, private investigator. You are now the government. You are working on behalf of the government. You are working at their direction. You are furthering the governmental purpose. I understand you're a private investigator, but not today. You are now the government. Congratulations. And other examples can appear. So it is possible for a private person to be the government under certain circumstances. Just as a note. In run-of-the-mill case, state action is easy to spot. Fair enough. Courts do not ordinarily pause to consider whether whether the section applies to the acts of public do not normally pause to consider where the section applies to the actions of police officers, public schools, or prison officials. Sometimes, however, the line between private conduct and state action is difficult to draw. In Griffin versus Maryland, for example, it was the source of power, not the identity of the employer, which controlled in the state of a deputized sheriff who was held to have engaged in state action while employed by a privately owned amusement park. Right? Again, like the example I sort of mentioned, right? The police hire a private investigator, or in this case, the other way around. In this case, a private amusement park hired the police, but they might still be the police. So, yeah. So who's paying you is part of the issue, but not necessarily all the issue. Okay. Since Griffin, most state action precedents have grappled with whether a nominally private person engaged in state action, but this case requires analyzing whether a state official engaged in state action. As I said, right, sometimes that is usually the issue. Hey, are you a private person? Are you really? Are you really a private person? So sometimes we struggle with that because we need to know when you cross the line, but this is a little bit differently. It's because we're talking about someone who is in fact a state official, but we're trying to figure out whether they're acting as a state official, because not necessarily everything they do is governmental action for any number of reasons. When your friendly police officer just goes to the local convenience store and just buys something, he's not acting as the government in that moment, because, you know, there's nothing about his state function that's relevant to that at that moment. So that might be an example. Freed's status as a state employee is not determinative. The distinction between private conduct and state action turns on substance, not label, which is often true in law. This is often true in law. We don't really talk about the label on the thing, we talk about the thing. Right? We're not concerned about labels because, well, we don't allow you to manipulate the law that way. It's like, yes, I'm not really a police officer. I'm really just Joe. I'm just really Joe. You know, I'm not really a police officer today. You know, I just went into the house and did a search in my own private capacity. I'm not really the police. I just did it personally. Sure you did. So usually the label on the thing is not what matters. We don't care what you call it. We care what it is. So fair enough. Private parties can act with the authority of the state. We've given some examples there too. And state officials can have private lives. That's fair enough too. Including the First Amendment right to speak about their jobs and exercise editorial conduct control over the speakers on personal platforms. So yes, you can talk about your job in your own personal capacity. That's fine, which makes sense because there's nothing really about your job unless you are a public relations official, in which case maybe we're doing a different analysis. But unless you're, you know, a PR person in your governmental capacity, there's nothing about your job that typically requires you to speak. And so the fact that you speak is probably not a function of your job inherently. And even if you are a PR person, even if you are hired to talk to the public, that doesn't necessarily mean every time you talk, you are in that role. Because even the White House press secretary has a personal life too. So that's what they're talking about. Here, if Freed acted in a private capacity when he blocked Lindke and deleted his commentary, he did not violate the First Amendment. Fair enough, right? If it's private, then the First Amendment doesn't apply and we don't care. We all move on with our lives. In the case of a public official using social media, a close look is definitely necessary to categorize the conduct. So we're going to have to go do this fact specific because we have to go untangle. Fine. In cases analogous to this one, precedent articulates principles to distinguish between personal and official communications in social media contexts. A public official's social media activity constitutes state action under 1983 only if the official possessed actual authority to speak and purported to exercise authority when he spoke on the media. The appearance and function of the social media activity are relevant to the second step, but they cannot make up for lack of state authority at the first. So you can scream all you want, I am speaking for the government, my words are the government, but if you don't actually have authority, then, we don't care. Because, you're just a guy screaming at the wind. So if I just, go on social media and be like, yes, I'm the government, I'm speaking on behalf of the government, it doesn't make it true. Also, the government may have words with me, because perhaps I'm committing a fraud or other things, but that's, another problem for another day. So the appearance of the social media cannot make up for the fact that you need to have actual authority in the first place, which, fair enough. The test's first prong is grounded in a bedrock requirement that the conduct alleged causing the deprivation of the federal right be fairly attributable to the state. We only care about state action. Link's focus on appearance skips over the critical step. Unless Freed was in possession of authority to post city updates and regular citizen concerns, his conduct is not attributable to the state. Okay. Importantly, Link must show more that Freed had some authority to communicate with residents on behalf of the government. The alleged censorship must be connected to speech on a matter within Freed's bailiwick. There must be a tie between the city official authority and the gravamen of the complaint. Okay, looks like we're looking for something a little bit more narrow than might have been first suggested, but that's sort of where we are. To misuse power, one must possess it in the first place. And 1983 lists the sources of power: statute, ordinance, regulation, custom, or usage. Determining the scope of power requires careful attention to the relevant source of that power and what authority it reasonably encompasses. The threshold inquiry to establish state action is not whether making official announcements could fit within a job description, but whether making such announcements is actually part of the job attributable to the state. So it looks like we are looking for actual authority to communicate on behalf of the state. So it looks like we're looking for a more narrow rule here. So this would strongly suggest that most governmental social media accounts are not the government, because most time they don't have, whether it's actually part of the job or not. For a social media activity to constitute state action, an official must not only have state authority, but must also purport to use it. If the official does not speak in furtherance of the official responsibilities, he speaks with his own voice. Here, Freed's account had carried the label, "This is the personal page of James Freed." He would be entitled to a heavy presumption that all the posts were personal, but the page was not designated either personal nor official. Again, the label isn't necessarily the thing. Just because you put the label on it, this is just the personal opinions of so-and-so, doesn't, of course, make it true. But it is suggestive, not for reasons that you're providing a disclaimer to the public in the first place. But, we're willing to look past that under the right set of circumstances. We always like to have flexibility to deal with people's machinations because people are endlessly creative. The ambiguity surrounding the page requires a fact-specific undertaking in which the post's content and function are the most important considerations. A post that expressly invokes state authority to make an announcement not available elsewhere is official, while a post that merely repeats or shares otherwise available information is more likely, but not necessarily, personal. Lest any official lose the right to speak about public affairs in his personal capacity, the plaintiff must show the official purpose. The official purports to exercise state authority in the specific posts. The nature of the social media technology merits to the analysis. For example, because Facebook's blocking tool operates on a page-wide basis, because a court would have to consider whether Freed had engaged in state action with respect to any post on which they wished to comment. So, although we can do this one by one, if we're talking about just deleting comments, that's one thing, but if we're talking about blocking people completely, that's potentially another thing altogether. And so that is the head notes of the thing. So let's read a little bit more. And Justice Barrett delivers a unanimous opinion of the court. Oh, great. So let's read this in a little bit more detail now that we understand the summary of the thing and understand a little bit more. Like millions of Americans, Mr. Freed maintains a Facebook page on which he posts about a wide range of topics, including his family and his job. Like most Americans, Freed occasionally receives unwelcome comments on his posts. In response, Freed took a step familiar to Facebook users. He deleted the comments and blocked those who made them. For most people with a Facebook account, that would have been the end of it. But Kevin Lindke, one of the unwelcome commenters, sued Fried for violating his rights to freedom of speech. Because the First Amendment binds only the government, this claim is a non-starter if Fried posted as a private citizen. Fried, however, is not only a private citizen, but also the city manager of Port Huron, Michigan. And while Fried insists his Facebook account was strictly personal, Lindke argues that Fried acted in his official capacity when he silenced Lindke's speech. When a government official posts about job-related topics on social media, it can be difficult to determine whether the speech is official or private. We hold that such speech is attributable to the state only if the official possessed actual authority to speak on the state's behalf and purported to exercise authority when he spoke on social media. Sometime before 2008, when he was a college student, Mr. Fried created a private Facebook profile that he only shared with friends. In Facebook's lingo, friends are not necessarily confidants or even real-life acquaintances. Users become friends when they accept a friend request from another. After that, the two can generally see and comment on one another's posts and photos. When Fried, an avid Facebook user, began nearing the platform's 5,000-person friend limit, he converted his profile to a public page. This meant that anyone could see and comment on his post. Mr. Fried is apparently a popular guy. Fried chose public figure for the page's category, James Fried for the title, and James R. Fried 1 as his username. Facebook does not require Fried to satisfy any special criteria to either convert his Facebook page to a public page or to describe himself as a public figure. So Facebook is like, okay, you want to call yourself that? We're fine with it. We don't care. Fine. In 2014, Fried was appointed the city manager of Port Huron, apparently Michigan, and he updated his Facebook page to reflect the new job. For his profile picture, Fried chose a photo of himself in a suit with the city lapel pin. In the About section, Fried added his title and a link to the city's website and the city's general email address. He described himself as daddy to Lucy, husband to Jesse, and city manager, chief administrative officer for the citizens of Port Huron, Michigan. As before his appointment, Fried operated his Facebook page himself. And as before his appointment, Fried posted prolifically and primarily about his own personal life. He uploaded hundreds of photos about his daughter. He shared about his outings, like daddy-daughter dance, dinners with his wife, and family nature walk. He posted Bible verses, updates on home improvement projects, and pictures of his dog, Winston. Nice. Fried also posted information related to his job. He described mundane activities like visiting local high schools, as well as splashier ones, like starting reconstruction of the city's boat launch. He shared news about the city's efforts to streamline leaf pickup and stabilize water intake from a local river. He highlighted communications from other city officials, like press releases from the fire chief and an annual financial report from the financial department. On occasion, Fried solicited feedback from the public. For instance, he once posted a link to a city survey about housing and encouraged his audience to complete it. Fried's readers frequently commented on his posts, sometimes with reactions. For example, "Good job, it takes skills," on a picture of his sleeping daughter, and sometimes with questions. For example, "Can you allow city residents to have chickens?" I didn't know that this was a thing in Port Huron. Apparently, some of the citizens of Port Huron would really like to have chickens. Okay. Chickens is where it's at. Noted. Fried often replied to the comments, including by answering questions from the city residents. City residents can have chickens, apparently, and should call the planning department for details. We are a pro-chicken community here in Michigan. Neat. He occasionally deleted comments that he thought were derogatory or stupid. After the COVID-19 pandemic began, Fried posted about that. Some posts were personal, like pictures of family spending time at home and outdoors to stay safe and save lives. Some contained general information, like case counts and weekly hospitalization numbers. Others related to Fried's job, like description of the city's hiring freeze, and a screenshot of a press release about relief packages that he helped to prepare. Enter Kevin Lindke. Unhappy with the city's approach to the pandemic, Lindke posted visited Freed's page and said so. For example, in one response to Freed's post, Lindke commented that the city's pandemic response was abysmal and the city deserves better. When Freed posted a photo of himself and the mayor picking up takeout from a local restaurant, Lindke complained that while the residents were suffering, the city leaders were eating an expensive restaurant instead of out talking to the community. Initially, Freed deleted the comments. Ultimately, he blocked them. Once blocked, Lindke could no longer see the posts. He could still see the posts, but could no longer comment on them. Lindke sued Freed under 1983, alleging that Freed had violated his First Amendment rights. As Lindke saw it, he had the right to comment on Freed's Facebook page, which he characterized as a public forum. Freed, Lindke claimed, had engaged in impermissible viewpoint discrimination by deleting unfavorable comments and blocking the people who made them, which sounds really, really bad, because viewpoint discrimination is about as bad as it gets. Don't do that. You know? You can't only delete the comments that you don't agree with if you're the government. That is not an option. You know, you can't do that. The district court grants summary judgment to Freed because only state action can give rise to liability, which is certainly true enough as far as it goes. Lindke's claim depended on whether Freed acted in a public or private capacity, which certainly is true. That is what matters. The prevailing personal quality of Freed's posts, the absence of governmental involvement with his account, and the lack of the post conducting official business led the court to conclude that he managed his Facebook page in a private capacity. It appears that the court below is trying to treat this as sort of an all or nothing proposition. So they're trying to categorize the entire page. Is the entire page or the entire account, as the case may be, is it private or is it public? And so they're trying to look to the comments to try to decide whether or not the page as a whole or the account as a whole can be characterized one way or another. The Sixth Circuit affirmed. It noted that the case law is murky as to when a state official acts personally and when he acts officially. It can be a little bit challenging. To sort that personal from the official, that court asked whether the official is performing an actual or apparent duty of his office, or if he could not behave as he did without the authority of his office. Because if he can do what he's doing without the authority of his office, then it's strongly suggestive that it's not his official capacity. Because he doesn't need his official capacity to do it, because he can just do it because he's just a guy. So if he can just do it because he's a guy, then it's pretty suggestive it's not official. Also, it's worth noting here, by the way, that we need to distinguish the powers of the office from the individual, even in a slighter context, because we got that idea about commenting about your job, right? Which is just something anyone can do. Anyone can talk about their job publicly. The fact that you're a governmental official is neither here nor there. So generally speaking, the power to talk about the power to talk about your job is not something that emerges from your job role, typically speaking, absent being PR or, public relations or something like that, right? It is not something that emerges from your job function. And even if it is something that emerges from your job function, there's still a line to be had because you're not necessarily on all the time. People have personal lives too. If you happen to be, chief public relations officer for, ExxonMobil, and you're just talking about your kid's baseball game, there's nothing about being chief public relations officer for ExxonMobil that has anything to do with your kid's baseball game. And there's also a difference on speaking on behalf of the company and speaking about the company, although that gets a little bit trickier, right? Because even if you're chief public relations official for ExxonMobil, and you merely say, I like my job is good, I like working for Exxon is great, maybe you're just talking about your personal life. Or maybe not. Or maybe you say you don't like your job, in which case you're probably most certainly not talking on behalf of ExxonMobil. I don't really like being chief PR person very much. It's not really that great, but I do it to pay the bills. There is a difference between the two. Now, of course, if you're ExxonMobil and you want to fire the guy, well, that's a little bit different now, isn't it? Because you're a private actor. So, if you're ExxonMobil and, like, we really don't like you bad-mouthing us, so we really would like to fire you very much for bad-mouthing us as our chief PR person. That seems counterproductive. Please go away. But if you're the government and you're like, hey, this guy's talking bad about the government. I'm a government official. I work for the government. I think the government sucks. I don't really like the government very much. I don't like my job. They suck balls. And the government's like, hey, we'd like to fire you for, disparaging the government. It's like, wait, you're the government. So it gets a little bit more tricky, right? You got to be careful here because there's lines. But, that's the kind of thing we're talking about. Applying the precedent, such as it is, to the social media context, where this is definitely more novel, the Sixth Circuit held that an official's activity is state action if, and this is the Sixth Circuit's opinion, by the way, so this is what they thought before we get to what the U.S. Supreme Court thought, if the text of the state law requires an office holder to maintain a social media account, I mean, one would think that would do it, the official uses state resources or governmental staff to run the account, I mean, that seems more suggestive, or the account belongs to the office rather than the individual, which all seems fair enough. These situations, the Sixth Circuit explained, make the official's social media activity fairly attributable to the state. So the Sixth Circuit is looking for a fairly narrow rule to avoid sweeping in too much conduct, which, fair enough. Because we want people to be able to speak on their own rights, and, just because you're a member of Congress or just because you're president of the United States or just because you're whatever doesn't necessarily mean you have to be that all the time. Even the president of the United States is allowed a personal life. And, personal thoughts that aren't necessarily from his office. All right, so the Sixth Circuit concluded that this was not the situation, that this was governmental stuff. The Sixth Circuit approach to state action in the social media context differs from that of the Second and Ninth Circuit because, of course, this is not the first time this issue has been raised. And, because more and more circuits are dealing with it, that's kind of where the Supreme Court usually gets interested. So we have a bit of a split of opinion on this increasing topic. Time for the Supreme Court to get involved. So the Sixth Circuit differs from the Second and Ninth Circuits, which focus less on the connection of authority of the account and more on whether the account appears to be official. So the appearance of the thing versus the thing. Actual conflict of interest versus perceived conflict of interest, if you want to bring that idea back. So what does it look like? What does it look like, and what is it? So there's at least two different approaches that have existed somewhat potentially in conflict. 1983, 42 U.S.C. 1983 provides that there's a cause of action against every person who, under color of law, or under color of statute, ordinance, regulation, custom, or usage of the state, deprives someone of a federal, constitutional, or statutory right. As the text makes clear, this provision protects against acts attributable to the state, not those of a private person. Private person can do whatever they want within the context of the First Amendment. This limit tracks that to the 14th Amendment, which obligates the states to honor constitutional rights, but not so much people. The statutory requirement of action under color of state law and the state action requirement of the 14th Amendment are identical. The need for governmental action is also explicit in the Free Speech Clause, the guarantee that Lindke invokes in this right. In short, the state action requirement is both well established and reinforced by multiple sources. That is certainly true. In a run-of-the-mill case, state action is easy to spot. Courts ordinarily do not pause to consider whether 1983 applies to the actions of police officers, public schools, or prison officials, and then we give some citations. Although in those situations, they are acting as governmental officials, so there's still that. And absent some very unusual facts, no one would credit a child's assertion of free speech rights against a parent, or a plaintiff's complaint that a noisy neighbor unlawfully searched his garage. Well, I mean, not under 1983 maybe, but although again, when we're talking about a private person, whether your neighbor searched your garage, again, if if they were suggested to do so by the government, if the police were the one, providing that suggestion. Hey, how about you go over there and check your neighbor's garage? We'd really like you to go look into that, right? So there might be some circumstances, but that is a little bit more nebulous. Sometimes, of course, the line to draw between private conduct and state action is difficult to draw. In Griffin versus Maryland is a good example. There we held that a security guard at a privately owned amusement park engaged in state action when he enforced the park's policy of segregation against black protesters. Though employed by the park, the guard had been deputized as a sheriff and possessed the same power and authority as any other deputy sheriff. The state therefore had allowed its power to be exercised by someone in the private sector, and the source of the power, not the identity the employer, controlled. By and large, our state action precedents have grappled with variations of the question presented in Griffin. Whether a nominally private person has engaged in state action for the purposes of 1983. Hey, private person, are you suddenly the government? You might be. What'd you do? Or more importantly, what did the government do? Today's case, by contrast, requires to analyze whether a state official has engaged in state action or is a private citizen. Which are they? The court has had little occasion to consider how state action requirement applies in this circumstance, which is true enough. The question is difficult, especially in a case involving a state or local official who routinely acts with the public. Such officials may look like they're always on the clock, making it tempting to categorize every encounter as part of the job. But state action doctrine avoids such broad brush assumptions, and for good reason. While public officials can act on behalf of the state, they are also private citizens with their own constitutional rights. Even the President of the United States has First Amendment rights unto himself, because the President of the United States is not necessarily the same thing as Joe Biden, for example. Those are different things. It's the difference between the office of the President and the President, right? The president gains his power from the office of the president. He's just borrowing it for the moment, right? So there's a difference between being the office of the president and being the man. Makes sense? By excluding from liability actions of officers in the ambit of their personal pursuits, the state action requirement protects a robust sphere for individual liberty for those who serve as public officials, which is probably a good thing. We don't always want to be on the clock all the time. The dispute between Lindke and Freed illustrates the dynamic. Freed did not relinquish his First Amendment rights when he became city manager, nor does anyone. That's not a thing. On the contrary, the First Amendment protects the public employee's right in certain circumstances to speak as a citizen, addressing matters of public concern. You're not always on the clock, man. That makes sense. This right includes the ability to speak about information related to or learn through the employment, so long as the speech itself is not ordinarily within the scope of duties. Where the right exists, editorial control over the speech and speakers on the public employees' properties or platforms is part and parcel of it. Thus, if Freed acted in his private capacity when he blocked Lindke and deleted his comment, he did not violate his First Amendment rights, instead exercising his own. So Lindke cannot hang his hat on Freed's status as a state employee. The distinction between private conduct and state action turns on substance, not label, which is very true in legal analysis, just generally speaking. We don't care about the label, we care about the thing. We don't care whether you call yourself something or call yourself something else. We care about the thing. That's very true. The distinction between private conduct and state action turns on the substance. Private parties can act within the authority of the state. We've discussed some scenarios where that's possible. And state officials can have private lives. Categorizing the conduct, therefore, requires a close look. So a private person can be the government, and the government can be a private person. Or a person in the government can be a private person, more of the point. A close look is definitely necessary in the context of public officials using social media. There are approximately 20 million state and local government employees across the nation, with an extraordinary wide range of job descriptions, from governors, mayors, police chiefs, to teachers, healthcare professionals, and transportation workers. Many use social media for their personal communication. Official communication or both, and the line between the two is blurred. So, we got quite a lot of people who have some sort of governmental role in some way. Moreover, social media involved a variety of different and rapidly changing platforms. if with distinct features, viewing and removing speech. Courts frequently emphasize the state action doctrine demands the fact-intensive inquiry. We repeat the caution here. That said, our precedent articulates principles that govern cases analogous to this one. For reasons we explain below, the public official's social media activity constitutes state action only if the official possessed actual authority to speak on the state's behalf and purported to exercise that authority when they spoke on social media. The appearance and function of social media accounts are relevant at the second step, but they cannot make up for a lack of authority on the first. If you don't have authority, then none of this matters. And you might, in fact, be a governmental official, but it doesn't necessarily give you authority to speak on this issue. Or, so there's, you know, it requires a little bit more of a careful look. The first prong of the test is grounded in the bedrock requirement. The conduct allegedly causing the deprivation be fairly attributable to the state. Only state action matters. An act is not attributable to the state unless it's traceable to the state's power or authority. Private action, no matter how official it looks, lacks the necessary lineage. So again, you know, just because a private official puts on a cop uniform and drives what looks suspiciously like a cop car doesn't make it so. You know, if some guy out there is pretending to be a cop and driving, you know, what looks like a cop car and driving in a cop uniform and, you know, hands you what looks like a warrant and so forth and so on, you know, it might all look official, but it's not. In other words, it's a lie. But, you know, yeah, and maybe some of the things that this person has are in fact state things, but they're not what they purport to be. So, you know, there's lines here. The rule runs throughout our cases. Griffin stresses that the security guard was in possession of state authority and purported to act under that authority. West versus Atkins states the traditional definition of state action requires the defendant have exercised power possessed by virtue of state law and made possible only because the wrongdoer is clothed within the authority of the state law. Lugar emphasizes that state action exists only when the claimed deprivation has resulted from the exercise of a right or privilege having its source of state authority. By contrast, when the challenged conduct entails functions and obligations no way dependent on state authority, state action does not exist. Lindke's focus on appearance steps over the critical step. He insists that because freed social media activity constitutes a state action because the Facebook page looks and functions like an outlet for city updates and citizen concerns. But Freed's conduct is not attributable to the state unless he was possessed of authority to post updates and register citizen concerns. If the state did not entrust Freed with these responsibilities, it cannot be fairly blamed for the way that he discharged them. Lindke imagines that Freed can conjure the power of the state through its own efforts, yet the presence of state authority must be real, not mirage. So just because Freed does it, doesn't make it so, just any more than if you weren't elected to office in the first place, right? So although it becomes a little bit harder to determine in fact, in principle, we understand. You know, if just a random guy has a Facebook page and is like, please, I want to hear your comments about the city and your thoughts, and people provide comments, and he answers comments, and suppose his answers are exactly what the government would give, just because he happens to be well informed. He's just a guy, but he pays attention. And so he says, you know, come to me with your concerns about the city, and people ask him questions and he answers questions. He's like, when is trash pickup? And he gives the answer, and it's the right answer. What do I do about, you know, city water concerns? He gives the answer. It's the right answer. You know, how do I respond to this, or how to respond? He gives answers. It's the right answer. So, you know, you can imagine, and there are people like that, you know, who just happen to be particularly well informed, particularly if they're local, because it's easier to be well informed if you're local, because, well, maybe you're just particularly engaged in the community and there's less things to know about in a locality versus the state versus the nation. So maybe you're just particularly well informed. So that guy isn't suddenly the city just because he's giving accurate information. Even if he says, you know, I'm acting on behalf of the city, if it's not true, it's not true. And he might be violating a crime at that point, by the way, by by pretending to be something he's not, right? By pretending to be authority, and he's not authority, now he might be violating the law. Like just as surely as if he put on a cop uniform. Even if it's exactly what a cop would do, it doesn't make it okay. Right? If you have a guy who's running around in a fake police car and in a fake police uniform, even if he does exactly what a cop would do, he doesn't actually have authority to do the thing. And he's fronting that he's the thing. So if he's representing himself as the thing, that's a whole nother set of problems. But even if he's representing himself as the thing, it doesn't make it so. So you can't impute it to the state. The state certainly didn't give him the power. In fact, the state's probably going to prosecute him for it. So, you know, if that's true, it's also true of a guy who actually has authority. Because he actually has authority, but now you have to tell the difference, which is harder in fact, right? If he never had authority in the first place, you know, if he never was a cop, for example, and he's pretending to be a cop, then it becomes a lot easier. But what if he really is a cop? Is he always a cop for all purposes at all times? You know, or is he always a, you know, accountant for the Treasury, or is he always whatever, right? Is he always a DMV employee? You know, that can't be the right answer. So it becomes a little easier. It becomes a little harder to separate because now you do actually have some real authority that really exists, but you still have to try to separate the difference. And merely the label doesn't make it true, which is fair enough. Importantly, Lindke must show more than Freed has some authority to communicate with residents on behalf of the city. The alleged censorship must be connected to speech on a matter within his bailiwick. He is the city manager, so that's going to cover a lot of ground, but in principle, right? So it has to be something within his authority. Now, because he's the city manager, that's going to be a lot. But of course, we're not speaking about Freed anymore. We're speaking about other people in other positions and what they could speak to or what they can't speak to or what their job is. So that's what we're talking about. For example, imagine that Freed posted a list of local restaurants with health code violations and deleted snarky comments made by other users. If public health is not within the portfolio of the city manager, then neither the posts nor the deletions will be attributable to the state authority because he has none. He is not the health inspection department. He's the city manager, so, you know, that's not necessarily within his role. Fair enough. For state action to exist, the state must be responsible for the conduct of which he complains. There must be a tie between the authority and the gravamen of the complaint. To be clear, the misuse of power possessed by virtue of state law does constitute state action. While state action doctrine requires that the state have granted an official the type of authority he used to violate rights, the power to arrest, it encompasses cases in which peculiar action of arrest made with excessive force violated federal law. All right, I'm going to go ahead and pause for just a second because I've been talking for quite a while, and I just want to see how we're doing in terms of understanding, if there's questions, what thoughts you have, concerns, what you think. Is there anything I can answer for you? How's the sound working? So forth and so on. I noticed in listening back to the last few live streams that I was having a bit of a clipping issue at the end of sentences where it would clip off a little bit and you'd lose like the last word of a sentence. I noticed in the last couple live streams, so I did make an adjustment. Most notably, I just kept open the gate longer because I have a gate for a noise floor. So I just kept open the gate longer so that when my volume drops below the level, it just keeps the gate open. I adjusted it from, I think, 100 milliseconds to a full second. So I adjusted it from 100 milliseconds to 1,000 milliseconds. So when my volume drops below the requisite level, it stays open for a full second, so no longer you'll have the clipping at my end of my words. So that's nice. See, no clipping of sentences. See, this is good. I noticed it when I listened back. I listened back and I was like, oh, I'm losing the last bit. I'm losing sometimes the last word. And I was like, this is bad. It's like I lost the last word. This is bad. Can't have that. So we'll just keep open the gate for a full second. That sounds pretty good. That's a long ass time in audio. I noticed it slightly, but figured it was just the filter we were using on the cord audio. No, I think it was the noise gate. Also, I lowered the noise gate. I lowered it from 30 decibels to, I lowered it from negative 30 to negative 35. So it triggers faster. So, just some ideas. Do you have any other questions, by the way, as we're also talking about noise issues? I sound great and look great. I thank you. I just had a shower. I went to the gym today. I feel wonderful. Nate and I went to the gym today, and I feel great. Can I say all the things again? Absolutely not. But I love you, Tom. So, are there any comments about this, or do we understand everything so far? You know, I have the best audio. I do try. I do try to have good audio. I do try. Yeah. What if the Dark King asks, what if the city's calling him on the phone and telling him maybe he shouldn't pick up certain people's trash, so they might want to sell their land cheap and leave the city? Well, I mean, if the city's directing him to do something, the city's directing him to do something. So if the city's directing him to do a thing, that's governmental action. So I don't know what scenario you are, but if the government is directing him, the government's directing him. Just as surely as if a police officer is just hiring a guy to be a detective for the day or whatever, right? So, yeah. Nate the gymnast or Nate the lawyer? I don't know Nate the gymnast, but maybe Nate the gymnast and I can be friends. Does he live in Houston? That'd be fun. Yeah, gym bros represent. I know. We had a good day today. I had a good day today. Is there a new address to send stuff? There is, in fact. It's on my link tree. And one of you guys did send me something. In fact, I can open it on stream. You sent me a letter or something. Here it is. Let's read it on stream because I haven't opened it. All right, so this comes from Dakota in Michigan. Dakota in Michigan sent me a letter or a mail or something. Let's see what we got. All right. Ooh. Neat. Oh, it's a long letter. Okay. And it has something to do with gold. Okay. This might be a promo. This might be a promotion. So this may be an ad. We'll see. I'll read it to you. Greetings, Kurt. I counted to reach out to you to share something. I found you might take a legal interest. They're called goldbacks. Their smallest denomination is 1/100th of a troy ounce of gold up to 1/20th an ounce. They originated in 2019 in Utah as a voluntary local currency, claiming to be legal tender and under the Utah Legal Tender Act of 2011, which declares gold and silver to be legal tender for the state. Since then, they spread to 4 other states, New Hampshire, Nevada, Wyoming, and South Dakota, all of which have similar legal tender acts. My lay understanding is the power to coin money is granted to the federal government, so that's true. So these legal tender laws raise an eye. Then to have a private company come along and claim protection under them is quite interesting. The latter years changed voluntary local currency with something legal tender instrument, special or specter legal tender instrument, which is a big change in their claim for the use of these notes. It also looks like the latter years are trying to act as a promissory note when it says exchangeable by Goldback Inc. in U.S. gold coin to bear on demand. I've heard their CEO, Jeremy, make claims about them being legal tender in all states as a coupon-like device. I wonder if this is what he's referring to. Currently, the exchange rate is $4.56 on a goldback, making the 6 goldbacks included worth $27.36. Consider a donation for the years of excellent legal education on LawTube. If you're interested, it'd be cool to have an interview with one of their legal advisors, Benjamin, about them. And then he gives me an email for Benjamin, which is at goldback.com plus goldatm.com. Sincerely, Dakota. P.S. Your PO box is marked closed, so this was sent out when you reopened in your new location, which is true because it was marked closed for a while. And then they sent me this, which is $1, I guess. 1 Nevada Goldback. Apparently, this is 1/1000th of a troy ounce of 40. This is 1/1000th of a troy ounce of 24 karat gold. Ooh, exciting! I own gold now. Very exciting. No. And then I got a $5 of, oh, this is a Nevada Goldback, and then I got a $5 Utah Goldback, which is 1/200th of a troy ounce of 24 karat gold. Exciting. So I own gold now. I'm excited in my life. Very cool. Thank you for sending the letter, and I may look into the topic in a future video. I've never owned gold before. This is exciting for me. Yeah, apparently they are actual gold. I know, it's actual gold. It's apparently it's 1/200th of a troy ounce of gold. Kick ass. And then it says exchangeable. It says in small print, exchangeable by Goldback Incorporated in U.S. gold coin, the bearer on demand. I'm not sure what gold coin they can give me for this, but it's nice to know it's exchangeable. Neat. Thank you for the Goldbacks. I will post a picture of them on my community tab. Sounds about as valuable as when my dad was able to buy a share of the Green Bay Packers. Man, buying a share of the Green Bay Packers is pretty valuable, man. That's a good deal. If your dad is actually an owner of the Green Bay Packers, man, I'd take that deal, man. That's a hard share to get a hold of. That's pretty awesome. Gold is gold. Someone will take it. I know. I could eat it. I could dissolve it in vodka and make Goldschlager. I could do lots of things. Let's continue on with the story. The value is about $11. That sounds low. Or 1/1000th and 1/200th. So that's that's 6 200ths. Yeah, that's 6 200ths, I think. Which is 3 100ths. So it's 3% of the price of gold, and gold is it sounds low. At 200 per ounce, which would make it worth about $60 if I did my math correctly. That sounds wrong too. Hold on. Let's see. All right. Let's try this again. All right. So I need to convert to 200ths, right? So 1/1000th is the same thing as 5 200ths. So that's 6 200ths. Right? Which is 3 100ths, which is 3%. Right? And so if gold is trading at $21 an ounce, or $2,100 an ounce, then 1% is $21.70, which means 3% is 60, what, $5, give or take? How am I doing? Did I do okay? No? You got, no. When did I screw up? Lawyer doing math. I can do this. 1/1000th is the same thing as 5 200ths. Right? No? That sounds wrong. I fucked up. No, it can't possibly be true. I fucked up. I'm sorry. No. No, I fucked up. 1 200th is equal to 5 1,000ths. That's the right way to do it. So I have 6 1,000ths. That's the right way to do it. Okay. I fucked up. I did the math the wrong way around. Yeah. 1 200th is 5 1,000ths. So I have 6 1,000ths. So at 21, so it's $2.17 per thousandth, and I have 6 of them. So I've got about what, $13 or something like that? Okay, I'm closer. Yeah. Yeah. So it's, yeah, that's okay. Yeah, I converted the wrong way around. I converted the wrong way. I used to be good at math. Long time ago. I got $12. I got $12. Yes, still cool if you have a society collapses and government can't print money anymore, you have gold. Yeah, I'm a little bit dubious. In the event the society collapse, I'm not sure really gold will be worth much, to be quite honest. If society really collapses, because you can't eat gold. So, yeah, if society really collapses, I'm not sure gold really has that much value. Ammo has value, and cans of corn have value. You can't eat gold. So I'm not sure much value gold has in the apocalypse either, to be quite honest. It's shiny, but you can't eat it. So, yeah. Yeah. Society gives it value. Yeah. Society gives it, well, that's true. Society gives it value. But yeah, in the event of the apocalypse, what will have value is things that will keep you alive longer. So, a can of corn is worth quite a lot more than, a bar of gold, because you can't eat gold. All right, where were we? While the state auction, thank you for the gold backs, as we did, yeah. While a state action doctrine requires the state to have granted the official type authority used to violate rights, power to arrest encompasses cases where the particular action, an arrest made with excessive force, violates state or federal law. Well, I just lost my place. Okay. Okay, here it is. Where does power come from? Section 1983 lists the potential sources as statute, ordinance, regulation, custom, or usage. Statutes, ordinances, and regulations refer to the written law throughout which a state can authorize an official to speak on its behalf. Custom and usage encompass persistent practices of state officials that are so permanently and well settled that they carry the force of law. So a city manager like Freed would have authority to speak for a city if a written law like an ordinance empowered him to make official announcements. He would also have the authority, even in the absence of written law, for instance, to prior city managers' power to do so has become permanent and well settled. And if an official has authority to speak for the state, he may have authority to do so on social media, even if the law does not make it official. Determining the scope of an official power regulates careful attention to the relevant statute, ordinance, regulation, custom, or usage. In some cases, a grant of authority over the particular subject matter may reasonably encompass authority to speak about it officially. For example, state law might grant a high-ranking official like the director of a state department or transportation broad responsibility for the state highway system that, in context, includes authority to make official announcements on the subject. At the same time, the courts may not rely on excessively broad job descriptions to conclude that government employee is authorized to speak for the state. The inquiry is not whether making official announcements could fit within the job description, it's where making the official announcements is actually part of the job the state has entrusted the official to do. In sum, a defendant like Freed must have actual authority rooted in law or long-standing custom to speak for the state. The authority must extend to speech of the sort that caused the alleged rights deprivation. If the plaintiff cannot make the showing of authority, he cannot establish state action. Yeah. So, like, coining money is interesting. As long as it's readily exchangeable for U.S. currency, it's probably fine. I haven't done a deep dive analysis, but this is basically like where when Disney World issued its own money for a long time, they had Disney dollars for a very long time, as you might remember. I don't think they do it anymore. But the rule basically was like, as long, and by the way, for the same thing in like company script, if we want to go even further back than that, with company towns, and let's pay you in company script, and they're like, no. So as long as it's readily convertible to U.S. currency, it's probably fine. And also, of course, it can't look anything like U.S. currency, or you might have a counterfeiting problem. So that's probably correct. So, plus the fact that it's gold means it's exchangeable by somebody. So that's nice. At the prevailing market price. It's probably more of a commodity than it is money. But voluntary local currency. I don't know what the hell that means. That probably doesn't mean anything. I'm sure their legal departments thought about it. For social media activity to constitute state action, an official must not only have authority, he must purport to use it. State officials have a choice about the capacity in which to choose to speak. Generally, a public employee purports to speak on behalf of the state while speaking in his official capacity or when he uses his speech to fulfill his responsibilities pursuant to state law. You know, if I ever get a gold YouTube button, it might be actually slightly hilarious if I actually embedded the thing with actual gold. Surely that must be possible. Embed to paint it with actual gold paint. That'd be cool. So it's really a really gold play button. That'd be cool. Something to think about for the future. Consider a hypothetical from an offline world. A school board president announces at a school board meeting, the board has lifted pandemic-era restrictions on public schools. Yeah, gold leaf. Pressed gold leaf. There you go. There you go. Gold leaf. Yeah. I like this plan. This is a good plan. Yeah, get it covered in gold leaf by someone who does that kind of work. I like this plan. This is a good plan. I like this plan more and more. The next day at a backyard barbecue with friends whose children attend public schools, he shares that the board has lifted the sanctions. The former is a state action taken by the official as a school board president. The latter is a private action taken as his personal capacity as a friend and neighbor. While the substance of the amendment is the same, the context, an official meeting versus a private event, differed. He invoked his official authority only when he acted as the school board president. Is this Supreme Court arguments? No, it's a Supreme Court decision. The context of the speech and also discussion about gold for some reason, because we got distracted, as we sometimes do. We ADHD'd and wound up on a rabbit hole of other discussion, which, you know, happens sometimes. It's okay. The context of the speech is hazier than that of the hypothetical school board president. Had Freed's account carry the label, "This is a personal account of James R. Freed," or disclaimer, "The views expressed are strictly my own," he'd been entitled to a heavy, though not irrebuttable, presumption all of his posts are personal. I own gold now. That we wound up in a distraction because I own gold now, which is exciting. Yeah, one of the uncivilians sent me gold in the mail, so hey, that's nice. If any of you guys would like to send me gold in the mail, that will be fine. I don't care about whether it's legal currency or not. I'll figure out that part later. Feel free to send me gold or palladium or, you know, platinum or any other precious metal will be fine. Thank you. Your thoughts are appreciated. I may or may not eat it. I'm half tempted to cut it up into small pieces and put it on ice cream just because it sounds hilarious. All right. Markers of this give speech the benefit of a clear context. Just as we can safely presume the speech at a backyard barbecue is personal, we can safely presume the speech on a personal page is personal, albeit significant evidence indicating the post is official. Conversely, context can make it clear the social media account purports to speak for the government, for instance, when an account belongs to a political subdivision. Freed's page, however, was not designated either personal or official, raising the prospect that it was mixed use, a place where he made some posts in his personal capacity and others as his capacity as city manager. Categorizing posts that appear on an ambiguous page, like Freed's, is a fact-specific undertaking in which the post's content and function are the most important considerations. In some circumstances, the post's content and function might make the plaintiff's argument a slam dunk. Take the mayor who makes the following announcement exclusively on Facebook. Pursuant to Municipal Ordinance 22.1, I'm temporarily suspending enforcement of alternate side parking rules. The post's express invocation of state authority, its immediate legal effect, and the fact the order is not available elsewhere makes it clear the mayor is purporting to discharge an official duty. If by contrast the mayor merely repeats or shares otherwise available information, for example by linking the parking announcement on the city's page, it's far less likely he's purporting to exercise the power of his office. Indeed, it's much more likely he's engaging in private speech related to the employment or concerning employment learned during the office. When I get a gold play button, have it replicated in solid gold. Solid gold might be a little unaffordable, but I appreciate your consideration. Maybe someday, but solid gold is probably a little unaffordable. I'm not sure how much gold that would be, but it would be a little pricey, especially for 24 karat gold. If I did 10 karat gold, maybe it wouldn't be so bad. Maybe we'll think about it. And heavy? That's true too. Hard to classify cases require where I'll use 25 karat gold because I'm just that special, guys. Hard to classify cases require awareness that an official does not necessarily purport to exercise his authority simply by posting about a matter within it. He might post job-related information for any number of personal reasons, from his desire to raise public awareness to promoting his prospects for re-election. Moreover, many public officials possess a broad portfolio of governmental authority that includes routine interaction with the public and may not be easy to discern boundaries between public and private lives. Yet, the officials too have a right to speak about public affairs in their private personal capacities. Lest any official you lose that right, it is crucial for the plaintiff to show the officials purporting to exercise state authority in specific posts. Have a marathon fund raised stream and gold in it? Pog. Yeah, Pog. I'll get it some sort of diamond encrusted gold thing that I can wear as a pendant and take and wear out to the clubs. Oof. I'm not. Maybe I could get a gold encrusted cowboy hat. That'd be good. Can you do that? Can you get a gold encrusted cowboy hat? That must be possible. Damn. I went to the Houston rodeo, by the way, which literally was my first rodeo. Incidentally, I went to the championships of the Houston rodeo yesterday. The last day of the rodeo in Houston, which was apparently the championships, and I saw people doing all kinds of fun rodeo events. There were a lot of people there. I'm not sure exactly what I expected, but it wasn't as much of a paddlum as one would expect. But I had fun. I was impressed. They were doing things I couldn't even dream of doing right now, so that was nice. I'll just paint myself in gold. That worked out really well for that lady in Goldfinger. She didn't really die, by the way. There was a long rumor, by the way, if you don't get the joke. That's a little bit of an obscure joke at this point. But there was a long-running rumor that the woman who was painted in gold for the movie Goldfinger really died. She didn't. But for some reason, that was a rumor for a while. But amazingly enough, she didn't really die in the filming of the movie. Wow. One last point. The nature of the technology matters to the state action analysis. Freed performed 2 actions to which Link objected. He deleted Link's comments and blocked him from commenting again. So far as deletion goes, the only relevant posts are those from which linked comments were removed. Blocking, however, is a different story, because blocked operations on a pace. My name is Pussy Galore. I must be dreaming. Sorry, we got distracted there. I had a rabbit run through my head. I mean, does it have to be quite on the nose? Man. Mythbusters did an episode on the painted gold thing. You're correct, they did. I remember that. You know, it isn't great. It prevents you from sweating properly, and therefore it can overheat. But it won't kill you from not being able to breathe. I remember. They left a 1 square inch unpainted at the base of her spine. Even if they painted her completely, she wouldn't have died. First of all, 1 square inch isn't going to make a difference. There's just no way. There's just no way 1 square inch is going to make a difference. And it's going to be fine as long as you're not, you know, exerting yourself. It's fine. A public official who fails to keep posts in clearly designated personal accounts, therefore, has exposed himself to greater liability. The state action doctrine requires Link to show that Freed had actual authority to speak on the behalf of the state and purport to exercise the authority. To the extent this test differs from the one applied by the Sixth Circuit, we vacate and remand, and is therefore ordered. All right, so that's that. And to wrap this up, we just have the 3-page per curum in the companion case, which basically says go see the case we just read and, you know, go away. So this is the case of Michelle O'Connor Ratcliffe versus Christopher Garnier et ooks. Et ooks. Really? What? What? I haven't seen. I didn't even know we used that anymore. Et ooks means and wife. Yeah, et ooks means and wife. I didn't even know we did that anymore. That okay. Yeah, et al means and others. Et ooks means and wife. Wow. Okay. Well, that's a one way to just roll a woman completely into this thing. Just be like, yeah, Christopher Garnier and his wife. Wow, okay. I didn't know we still did that in law. Fine. Yeah. The woman disappears into one word, ooks. All right, in 2014, Michelle O'Connor Ratcliffe and TJ Zane created public pages to promote their campaigns for election to the Poway United School District of Trustees. While O'Connor, Ratcliffe, and Zane, who we'll call the trustees, both have personal Facebook pages they share with their friends and family, they use their public pages for campaigning issues related to the school district. After they won the election, the trustees continue to use their public pages to post PUSD-related content, including post-board meetings recaps, application solicitations for board positions, local budget plans and surveys, and public safety updates. They also use their pages to solicit feedback and communicate with their constituents. Yeah. O'Connor Ratcliffe also created a public page. Christopher Garnier and Kimberly Garnier, also known as Ooks. Christopher and Ooks, who have children attending the school, often criticize the Board of Trustees. They began posting lengthy and repetitive comments on the trustees' social media posts. For example, nearly identical comments to 42 separate posts on O'Connor Ratcliffe's Facebook page and 226 identical replies within a 10-minute span to every tweet on her Twitter page. The trustees initially blocked Garnier and Ooks before blocking them from the commenting altogether. Thank you for the 10 gift memberships. They are extensively appreciated. The Garniers sued trustees under 1983 seeking declaratory damages and injunctive relief for the alleged violations of their First Amendment rights. Yeah, at Uxer. Remember your 9th grade Latin? Yeah, that's right. Yeah, we're remembering some old school language now. That's right. Yeah. At summary judgment, I'm going to call my wife Ooks. That'll be my pet name for her, and I'm not going to tell her why. Let's see how well that works out if I get married. I'll be like, hey, Ooks. It's like, why are you calling me Ooks? This is my pet name for you. What does it mean? That just means my love. Aww. I guess it literally means wife. So, I mean, it's just old school Latin. It just literally means wife. So, all right, that's fine. Google Translate? I'm not sure Google Translate knows this one. At summary judgment, the district court granted the trustees qualified comments to damages claim, but allowed the case to proceed on the merits of the ground that the trustees acted under color of law. The Ninth Circuit affirmed. It held that under 1983 state action requirement was satisfied because there was a close nexus between the trustees' use of their social media pages and their official positions. Yeah, Google Translate's not good at Latin. The court cited its own state action precedent, which holds that if an off-duty state employee acts under color of law, if she reports to or propends to act under the color of law, her pretense of acting in the performance of her duties had the purpose and effect of influencing their behavior on others, and harm inflicted on the plaintiffs related to some meaningful way to the duties. We grant cert in this case and in Link versus Freed to resolve the circuit split on how to identify state action. Because the approach the Ninth Circuit applied is different from the one we elaborated in the case Link that we've been discussing, we vacate the judgment below and remand to the Ninth Circuit with further proceedings consistent with her opinion in that case. So please go see the other case and go do that. In that context, it would be endearing. In this official court, though, that's not the same. That's fair. So if I call my wife Ooks, it's endearing because I'm just calling her wife. But in the course of the document, it's not that endearing. Yeah, it's like it just folds her in completely into her husband. It's like, okay, that's fun. I didn't know we did that anymore in law. That's hilarious. But okay, fair enough. I am also a bit of a sucker for like the tricks ending for things because it's old school. Executate tricks, executor and exec tricks, or testator and testate tricks, or dominator and dominatrix. That's where that comes from, right? Because of the female form. I'm a bit of a sucker for that tricks ending. Also, I'm not sure what the origin of that is in its original thing, but the fact that the female ending is tricks. Well, there's something in there somewhere too, right? Right. So I'm not sure if it's coincidental that the ending sounds like a trick, but there you go. There you go. That's fun. All right. Well, that will send us off for today. We do have one other opinion though from the U.S. Supreme Court. But I'm going to order some sort of lunch product. I'm going to order some groceries and hope they deliver. I need some sandwich meat, or maybe I'll just go to the grocery store. I mean, why not? Just go to the store and like buy things like a normal person. And suffrage, cute. And the suffrage, that's like, yeah. Let's end women's suffrage today. Yeah. I'm picking up what you're laying down. I know what we're talking about. Yeah. Oh, man. Good times. Language is fun. Language is fun. Although I do have to express disappointment because I was watching back one of my earlier streams because I was listening to the sound because I was noticing this issue with the clipping of the audio. So I was listening back to a prior stream and we were discussing the jury in what was it? The Crumbly case, James Crumbly. And then we had a whole stream where we thought the jury had a question and then we were like debating what did or did not happen because there wasn't a question read in open court and it was a whole thing for a while. And so we were discussing it for a whole long time. And someone asked me, well, what's the consensus? And I said, well, the consensus is that something is wrong in the state of Denmark. And I noticed one of the people in chat actually said, Denmark? ? Now, I didn't notice this at the time. Or else I would have chastised them. But I'm like, really? Really? Seriously? Apparently there's one guy, at least, right? What's the consensus about what's happening in this courtroom in America, in this case Crumbly? What is the consensus? And the consensus is like, the consensus is something's wrong in the state of Denmark. And someone said, Denmark? ? I'm like, really? Seriously? What you gonna do? What you gonna do? Hey, baby, talk Latin to you? Is Latin the language of love? Is that the good pickup lines? Well, they say French is, I guess, and I remember, I forget the quote, but it's like one of those quotes about the kids these days, right? Because one of the funny things is when people are always talking about the kids these days and how they are disrespectful and all the rest of it, there are quotes basically from every generation, and they're a little bit hilarious. So it does serve as a bit of a check on things. People were complaining about TV when it came out. One of my personal favorites is that people were complaining about books when they first were invented, right? People were complaining about books because, it's just the youth these days always burying their head in books and not engaging in civil conversation. There are quotes like that. There are people bitching about the invention of the book because the youth these days just always burying their head in the book and not engaging in social conversations. The end of society, man. The goddamn invention of the book. I think that's hilarious. Or wasn't it even like, was it which one was it? Was it like Plato bitching about the kids it was Aristotle, wasn't it? Aristotle bitching about the kids these days. There are quotes from that. One of my personal favorites from like these quotes about people bitching about, you know, the kids these days and all the rest of it. One of my favorites is a guy, I forget who, and I forget exactly what context, but he was bitching about how the kids these days weren't speaking proper Latin, you know, and their use of language. And what's funny is that he didn't know it at the time he was saying it, but what they were speaking was French. It was the start of the French language. It's like these kids these days they're not properly speaking Latin with their distortions, and they were speaking French, or what would ultimately become French. And I find that funny. It's just interesting. Was Socrates the one bitching about the kids these days? Okay, fair enough. The youth is wrong. We have no future. Yeah. So the kids these days, yeah. So there is some caution to be had about bitching about the kids these days. But by the same token, it is worthy of noting mistakes in the past. Because sometimes things have gone wrong. So sometimes worrying about the future is always reasonable because it's the unknown. It just has a tendency of working out more. Although sometimes it doesn't work out. Sometimes it leads to the collapse of civilization. So sometimes worrying about the kids these days is the right thing to worry about. Because, you know, was it Nero who saw the Visigoths come over the mountain? It's like, did you really know Rome was about to fall? So sometimes worrying about it is the right thing to do. Well, you know, yeah. America's a great country. Yeah, America's a great country because it's such a diverse country. It's a huge country geographically. It's about as big as Europe. And it's about as diverse as Europe, to be quite honest. Or arguably more diverse. It's got everything. It's got mountains, it's got rivers, it's got oceans, it's got plains, it's got deserts, and it's got every kind of people of every kind of stature and way of speaking and thinking. And America is a diverse place. The thing that foreigners tend to underestimate is how big America is. And they tend to underestimate like what they can do in a day. So it's sort of that cliche. You know, the foreigner coming to the United States, like, oh, what are you going to do while you're here? It's like, oh, how long are you going to be in the United States? Oh, I'm coming for a week. What are you going to do? Well, I'm going to go to New York, and then I'm going to go to Disney World, and then I'm going to go to, you know, the Grand Canyon. It's like, no, the fuck you're not. No, you're fucking not going to do those things. So that's a cliche. The foreigners not understanding how big the United States is. Oh, I did like this quote too. Recently, I read. I thought this was a very interesting observation. I think it was an expat British guy living in the United States who said it. But it was a very good observation, and he was saying, like, how people in the UK, when they'll say like, you know, where do you live, and they'll say, oh, I don't know, I live in Portsmouth. I don't know. And someone will be like, is that near London? And the funny thing is, like, to the British person, that's an absurd question. Because to them, it's nowhere close. But the funny thing, what the expat British guy points out is that from an American perspective, that's not an absurd question because they're close. From an American perspective, because our perceptions of distance are much less than the British perception. It's like that old cliche, like 200 years in the United States is a long time, but 200 miles in the UK is a long distance. Where it's the other way around, right? What's 200 years to a British person? About what 200 miles is to an American. I mean, you exaggerate slightly, but you get the point, right? So is Portsmouth close to London? It's like, well, to an American, it kind of is. I mean, your entire goddamn country is no bigger than Oregon. So, you know, it's like everything's kind of close to everything else from our perspective. But so that's just an interesting observation I thought was really funny. And it's like, so the British people are laughing at the Americans. Haha, they don't know they don't know where these things are. And the Americans are like, yeah, those are next door. It's just like the differences in perspective. And I think it's funny. Yeah. America is a great country. America is a great country. I reject this premise. I reject the premise that America was a great country and isn't anymore. America is a great country. America is fantastic. And in fact, you can make the argument, I think very credibly, America's as good as it's ever been. The struggles we have in America on a fundamental level are like no different than we've ever had. Like this power, the differences, the struggle between state power and federal power and like these things. But like America as a country kicks ass. Our biggest problems are more in the medium to long term, especially as it relates to debt. Because, at some point the bill's going to come due, and that's going to be pretty painful one day when we inevitably get to austerity because our politicians hate to do anything before the very last minute. So one day the bills are going to come due and we're not going to be able to pay them, and it's going to be ugly for a while. But, I think America's as good as it's ever been. America's great. America kicks ass. I'm proud to be an American. I love America. USA, USA, USA. Yeah, I mentioned to a Brit when I first moved 3,000 miles, they thought I moved to like Fiji. So no, just from the East Coast to the West Coast. I think they're only about 2,000 miles and change apart. Well, it depends, I suppose, where you're moving on the East Coast. So if you're moving diagonally, maybe it's closer to 3,000. But yeah, it's like, America's big. It's big. It's like, yeah. America's a great country. We have our problems, but so does every country. I'm not sure our problems are necessarily like worse on a fundamental level than any other country's problems on a fundamental level. America kicks ass. I said the Pledge of Allegiance yesterday at the rodeo, and I sang the national anthem and I cried a little. I'm not going to lie because it was heartfelt. So I love America. America's fine. Everything is awesome. Our biggest problems are more in the medium to long term, plus the potential existential threat of China as a growing power. Although that's not as much a problem today, but that's a growing problem. But those are more long term problems. New Jersey to California is almost 2,900 miles, is it? Okay, I'll take your word for it. I thought it was a little bit closer than that. I thought it was lower 2000s, but okay, I'll take your word for it. Still wild how everything stops in Texas for the national anthem. I don't think that's a uniquely Texas thing. I've been to many ball games and sporting events in many parts of the United States, and that's pretty typical. At least in my experience, I've sung the national anthem at sporting events in D.C. and New York, and at least in my experience, people tend to be pretty reverential everywhere. So that's not really a uniquely Texas thing, I'm pretty sure, but okay. Yeah. Everything, it's like I've sang the national anthem in many states. It's pretty typical, kind of everything stops for the national anthem everywhere. At least in my experience, so not sure what you're talking about on that one, but okay. Yeah. Yeah, we belted it out in the South. Well, people belted it out everywhere, but yeah, I mean, there's still a lot of pride everywhere in our nation, and God bless America for that. I cried a little at the national anthem. It didn't help that it was a bit of a spectacle at the national anthem at the sporting event. They had, when they had like the rockets let red blare, they actually had little fireworks inside, which is kind of cool. I mean, they're not strictly speaking fireworks, I suppose. They're like pyrotechnics, but still, like, that's pretty cool. And they had a woman riding a horse with an American flag, and then like at the crescendo, she like presses a button and like effectively a huge sparkler is coming out the top of the American flag. You know, she's wavering around. I'm like, I cried a little bit. That's fine. I have thoughts. Did I see the national anthem two Super Bowls ago? I'm not sure. But yeah, I cry. I cry. It's fine. America's great. It's a great national anthem. And it's a great song. And it's hard to sing properly because of the range. It's a little bit difficult. It's a little tricky. And it's a British pub song that we repurposed, but that's okay. It's fine. Yes, we stole your British pub song and now it's our national anthem. What do you want to do about it? You want to fight? Yeah. Man. Yeah, you come over here, take your British pub song back. Good luck to you. We'll cross your ass. All right, I'm gonna sign off for now. This has been fun. We will be on later today with more stuff. Yeah, we took Yankee Doodle. We also took "Oh Say Can You See," which is just "God Save the Queen." So we stole that one too. That's fine. We stole a lot of your shit. That's fine. Oh, say, can you see? What so proudly we have twilight's last gleaming. America the Beautiful. Oh, beautiful for spacious skies, amber waves of grain, purple mountains' majesty above the fruited plain. America, America, shed his grace on thee. Through the sea to shining sea. We stole English? Yeah, we made it American too. Yeah. So, yeah, fair enough. All right, guys, I'll sign off till later. My country 'tis of thee, sweet land of liberty, oh thee I sing. Land where my fathers died, land of the pilgrim's pride, from every mountainside, let freedom's ring. Yeah. I don't know what you stole, but I'm sure wasn't English. Cute, yeah. A people separated by a common language, as has been said before. But the funny thing is, like, the Americans are British, and the British sometimes don't like it, but it's true. Especially the South, because like the Southern language, the Southern is just it's a formal British with an allele. You know, it's funny too, because like hardcore Southern is just formal posh British with an allele. So my mother, let's see if I can do my best British here, or my formal British posh. My mother and father, you know, father, my mother, father. And then American Southern is like my mother and my father. And so it has that allele to it. It's the same goddamn thing. Yeah, that's right. Southern is British aristocratic English with an allele. Yeah, good times. It's with a sing-song cadence. Yeah, that's right. That's what we did with your British posh culture. We turned it into Southern. Woof. All right, I'm going to go to the grocery store and get some food. All right, I'm going to talk to you later. I love you guys. Bye-bye.